Hello, my name's Julie Williams. I'm a registered migration agent with Migration Downunder, and I'm going to be talking to you today about employer nomination scheme and the grandfathering clauses there available for certain visa holders of the 457 and possibly 482. Now, the employer nomination scheme is for those that have got a skilled occupation on the medium long-term list that are employed or have an offer of employment to transition through to permanent residency pathway. There's two different streams, actually three. There's the temporary transition stream, whereby you may have been working for your employer for a certain period of time to make you on a 457 or a 482 to make you eligible for applying for permanent residency. It may be that you haven't worked with your employer for the specific time to go through temporary transition stream, or you may be overseas with a job offer. Then there's a direct entry pathway that requires a skills assessment and a minimum 3 years work experience. Otherwise, the third stream is a labour agreement that the employer has with the government. Now, I'm going to concentrate more on the temporary transition stream and the grandfathering clause for those that held a 457 or had applied for a 457 prior to the major changes announced on the 18th of April 2017. So if you had submitted and lodged a 457 visa application prior to that date and it was later granted, then you're eligible for what's referred to as grandfathering clauses. The same if you held a 457 prior to those changes and you may have since extended or changed employers or have now gone on to a 482. If you haven't broken that and you've been consecutively on that 457 and then gone through to a 482, you may be eligible to what's referred to as our grandfathering clauses, because you may be in an occupation that has been either removed off the skilled occupation list, or it may be on the short-term list, which doesn't pathway to permanent residency for those who held or applied after that date in April 2017. So even if your occupation is on the short-term list, if you have been working with your same employer on the 457 or combined with a 482, then you're eligible to still apply for permanent residency. The same goes with if you are over 45, up to the age of 49, as long as you're under 50 and you've held your visa prior to the 18th of April 2017, that will also allow you to continue to pathway through to permanent residency. So it's good news for many people that don't realise this. It doesn't matter if you've changed employers because you will be able to continue to access that up until March 2022. So therefore, you can't really look at changing employers after March 2020 because you won't be able to transition or meet that 2-year employment requirement after March 2020. The grandfathering clauses is not available for direct entry, only temporary transition stream. So whilst those who are have recently obtained a 482 and have never held a 457, they have to wait 3 years before they can transition into permanent residency. Those that can access the grandfathering clause only need to be employed for 2 years. And of course, it is it's not automatic. The employer still has to make certain that they are offering a genuine ongoing position, and that position's available for at least 2 years from the grant of permanent residency. But look, there's probably a lot more that I haven't spoken about today that you may require answers to. So don't hesitate in contacting us on 02 9419 5411. Otherwise, if you do want to stay up to date with the latest immigration news, look at subscribing to our YouTube channel or perhaps subscribing to our newsletter. Otherwise, we do hold regular webinars on topics such as the employer nomination scheme and the grandfathering clause. We hold regular webinars every fortnight. So I hope that's assisted you in some way, and if not, don't hesitate in getting in touch.